So I believe the council addressing us on the personal issues will be Ms. Naserian, right?
Yes, Honorable Arbitrator.
Okay, you can start, please.
Thank you very much. May it please this Honorable Tribunal, my name is Naserian Kasura. I appear in this matter for the conduct of the respondent. With me is my co-counsel, Mogesi Joel. Having already established the time allocation to this Honorable Tribunal, I wish to proceed to the procedural issues. Thank you. Honorable Tribunal, indeed, it is trite law that this tribunal cannot proceed to listen, to determine, or to entertain this dispute if it lacks jurisdiction. It is a submission of the respondents that this tribunal lacks the requisite jurisdiction to determine this particular issue. Honorable arbitrators, in advancing our argument, the respondent shall use three limbs of argument. First, it is our response and our argument that indeed the Republic of Valdres is not a party to the Bilateral Investment Treaty of 2005. Our second limb of argument rather, will be that the Republic of Valdres did not at any point issue any express consent to be bound by the BIT of 2005. Thirdly, and finally, our last limb of argument with regard to issue number 2 is that the conduct of the Republic of Valdres cannot be used to infer any consent of any sort in this particular instance. With the leave of this Honorable Tribunal, I will now proceed to the first limb of our argument. That is, the Republic of Valdres is not a party to the Bilateral Investment Treaty. Honorable Tribunal, the Tribunal, in the case of Turquoise versus Ukraine, held that consent is the cornerstone of jurisdiction in the ICSID Convention. In this particular instance, Honorable Arbitrators, there was no consent from the respondents to be bound by the BIT. What then does this mean for this tribunal? If there was no consent from one of the parties to this particular dispute, then this Honorable Tribunal cannot exercise its jurisdiction. Honorable Arbitrators, it is trite law that consent can either be express or tacit. In addressing the second and third limbs of our arguments, we will prove that consent was neither issued expressly or by the conduct of the Republic of Valdres. On to the second limb of our arguments. The second limb of our...
Sorry to interrupt you. I have a question. You mentioned that actually your clients didn't accept the BIT by expressly or by conduct, but based on the fact of the case, your government accepts or join to the other BITs or contract with the other states, the other country, and I can actually take into consideration this act that your country accept this current BIT, the BIT in the case at hand, by conduct. How you justify that?
Apologies, Madam Arbitrator. I would like to take your question once more.
Okay. You mentioned that your country, your client, didn't accept the BIT in the actually case at hand, not expressed, not actually by conduct. But my question is that your country accept or actually join the other BITs, the other contract with the other countries, except the actually mainland of the investors. I actually take into consideration this action that your country accepts the joining this BIT and actually accept the BIT at hand by conduct. How you justify that?
Thank you very much, Madam Arbitrator. When it comes to the conduct of the Republic of Valdres, As is in our third limb, we will clearly show that the conduct of the Republic of Valdres cannot be used to infer consent. Why, you may ask? Indeed, at some point, we issued a notice, or rather a diplomatic note, being April 2023 to the claimants, saying that we were ready to be bound by the BIT agreement. But what then was our conduct after issuing this notice? This is what the tribunal needs to take into account. Allow me to break down the conduct for you. April of 2023, the Parliament in Valdres issues a declaration that they are no longer willing to be bound by this BIT. August of 2024, we relay this same information to the claimants in a bid to be clear and unequivocal in our stand that we are not willing to be bound by the BIT. This is the conduct that...
Sorry, Council. If you're talking about April, but before that, if you look at C1 and C2, there's also conduct. I mean, if you look, I can consider this as conduct because there's this letter signed by the Minister of Foreign Affairs of your clients, yeah, to the effect that actually, and this is sent to Zenera itself, basically saying that, okay, whatever that's been signed between them, Zenera and Arrakis, we are prepared to accept that now. And of course, it ends here saying that confirms, right? Last line, this Republic of Valdres, brother, your clients, confirms its readiness to observe and the treaties and agreements that have been effective between the Kingdom of Zenera and the Federal Republic of Arrakis, unless the parties agree otherwise. And then subsequently, of course, there was an acceptance of that particular note from the minister by the Minister of Zenera just a couple of days after that, who said, fine. So isn't that also conduct? I mean, you're talking about what was decided in April by the Parliament, but the point we are talking about is if you're talking about conduct, it would seem that conduct also is actually, it proves otherwise, right? What you're asserting to us.
Thank you very much, Honorable Arbitrator. Your question leads me to the second ambit of discussion raised by the respondents. With regard to the diplomatic notes, that is page 13, Exhibit C1, before this Honorable Tribunal, it is a submission of the respondents that the wording of this diplomatic note is not clear, unambiguous, and unequivocal enough to infer that we were willing to be bound by the BIT.
Okay, fine.
Honorable,
yes.
Thank you. Specifically, Honorable Arbitrator, the wording used is readiness. We were ready. And allow me to indulge the tribunal. Imagine you're preparing for a marathon. Every single day on the track, you go ahead to order merchandise, perhaps even sign up for the marathon physically. You are ready for the marathon. Does that then bind you to actually participate in the marathon? It does not, Honorable Tribunal. The diplomatic note sent by the Republic of Valdres to Zenera only expressed our readiness to be bound by the BIT.
Council, I like that example.
Sorry.
Council, hold on, sorry. Yeah, my apologies. I like that example you gave, but you could compare apple with apple, not apple with an orange, yeah? Okay, carry on, Ms. Clara. I was saying.
Thank you very much.
It is related to the example, like how we can understand or agree with your example when we are not talking about a marathon, we are talking about international obligations. So we cannot accept that a state says that it is not ready to have international obligations. If you are not ready, you are not making the succession that you did.
Thank you very much, Honorable Arbitrator. But from the wording of the diplomatic note, aside the analogy, it is clear from the literal interpretation of the wording that indeed we were only ready to be bound. Other than that, Honorable Arbitrators, allow me to draw your attention to the very said C1 exhibit on page 13.
Page what, sorry?
Page 13, Honorable Arbitrator.
I can't hear you.
My apologies.
Page?
My apologies. Can you hear me?
Yeah, now I can. Page what again?
Page 13.
Okay. Did she say 30 or 13?
13. Actually,
13.
Honorable
Huh?
Arbitrator,
1-3,
um,
is it?
1,
1-3.
3. Yeah.
Okay,
Now
okay.
allow
Yeah,
me,
sorry.
Honorable Arbitrators, to lead you to page 14 on the last statement. This was a response by the Republic, or rather the Kingdom of Zenera, to the Republic of Valdres with regard to the note sent. And it says, allow me to read the last statement. Especially with respect to treaties focused on economic and trade cooperation between the two states. Honorable Tribunal, if at all there is an argument that there was consent between these two parties, the consent was only for treaties that were meant to foster, one, economic and trade cooperations between the two states. This BIT agreement cannot be used to foster economic treaties, or rather economic relations.
Why?
Between states.
Well, I mean, what is the difference between a bilateral investment treaty and an economic and trade cooperation treaties?
Thank you very much, Honorable Tribunal. This BIT treaty was specifically for healthcare. These healthcare purposes cannot be used to infer that they were to bring an economic, profitable support to the
Why
Republic of
not? What is the object? I mean, what is the objective of or the purpose of a bilateral investment treaty in general?
It is to bring profits indeed, or rather
Okay,
to grow
so
the economy.
why we cannot take into consideration that this bilateral investment treaty can be included under the economic and trade cooperation?
Thank you very much for your question, Honorable Arbitrator. That would be a protraction because this particular healthcare sector has not been mentioned in the agreement. It would be a protraction of sorts. We cannot add factors to the things that these two parties contracted to. If they specifically contracted to economic treaties, then it should be so. Thank you very much, Honorable Tribunal. Honorable members of this tribunal, the claimants may argue that in April of 2023, the Republic of Valdres issued a declaration that they were no longer willing to be bound by the BIT agreement. Indeed, they may argue that this particular declaration was not valid since it was a unilateral declaration. Honorable Tribunal, allow me to point this tribunal to the case of New Zealand versus France, where the ICJ held that unilateral declarations could be binding if they were clear and unequivocal. Honorable members of this tribunal, it is a submission of the respondents that the note to the Republic, to Zenera or to the claimants in this particular issue was clear and unequivocal. The intention by the Republic of Valdres to no longer be bound by the BIT agreement was stated clearly in that note. Honorable Tribunal, it therefore goes without saying that indeed this unilateral declaration made by the Parliament in Valdres stands as valid and can be used to withdraw their consent if at all any consent was given in the very first place. Honorable Tribunal, on to our third ambit of discussion, which I believe was well answered during the question from Arbitrator Rehane. It is our submission that the subsequent conduct of the Republic of Valdres cannot be used to infer consent. Honorable arbitrators, allow me to point you to Article 31(2) of the Vienna Convention on the Law of Treaties, which provides that any subsequent practice in the application of the treaty that establishes this agreement must be taken into account. What then does this mean for this tribunal? That the conduct of the Republic of Valdres must be taken into account to indeed prove that there was consent. And we have already looked at the conduct of the Republic of Valdres. One, April of 2023, a declaration saying that they are not willing to be bound by this agreement.
Sorry. Okay, with the Vienna Convention, okay. But what happened with the Vienna Convention on subsection of responsibilities?
Can I please take your question again, Madam Arbitrator?
Yes. What about all the rules, all the international rules related to the subsection of international obligations? They are
Thank you very
applicable, they
much.
are not applicable.
Thank you very much, Honorable Arbitrator. Indeed, there can be succession of the treaties. And allow me to point your attention to Article 27.
And counsel, bear in mind that you only have got another 3 minutes
Thank you very much, Honorable Arbitrator.
to
Allow me
go
to
to
point.
proceed. Yeah. You please quickly summarize this point, and then you may have to move on to the next point about the monetary gold principle.
Thank you. Honorable Tribunal, allow me to point your attention to Article 12.3 of the IIL Resolutions of 2015, to which these two parties are part of. And it reads, if particular circumstances so require, the obligations arising from the commission of an international wrongful act by the predecessor state pass to the successor state when the author of that act was an organ of territorial unit of the predecessor state that has later become the organ of the successor state. To answer your question, Madam Abichita, indeed, these particular obligations can be inherited by the states, but in this particular instance, as we will prove, one, the PHO, who is the provincial health officer in Valdres, was not autonomous in the decision making. And two, as a result, they cannot inherit these obligations. With regard to issue number 2, as to whether this tribunal can exercise its jurisdiction, in light of the monetary gold principle objection, it is our submission as the respondents that indeed this tribunal can still exercise its jurisdiction. Why, you may ask? Honorable Tribunal, the ICJ in the case of Cameroon versus Nigeria held that it can only hesitate to exercise its jurisdiction in light of a monetary, thank you, Madam Arbitrator, for the time, in light of a monetary gold principle objection if and only if the legal interests of the absent party form the very subject matter of the judgment. This tribunal must then ask itself, what are the legal interests in this particular issue? Are they tied to the Republic of Arrakis? It is the respondent's submission that indeed they are. Honorable
Okay, counsel, sorry to ask you. I mean, you see, you may be confusing this, Are you actually saying, see, there are two different, I believe you know the difference between jurisdiction and admissibility.
Yes.
When you say that the tribunal doesn't have jurisdiction, that's it, I mean, basically, we don't have the power to even proceed. But whether something is admissible is another point. So are you actually saying this monetary gold principle relates to jurisdiction or admissibility?
Thank you very much for your correction, Honorable Arbitrator.
Because
Issue
from
number
what
2,
I see from your, because from what I see, from what
yes.
I've read in your case summary, you seem to confuse that thing. You're still harping on this jurisdictional issue when actually it should be an issue of admissibility.
Thank you very much, Honorable Arbitrator. Indeed, issue number 2 is with regard to admissibility. And the respondent's submission is that this Honorable Tribunal does not have jurisdiction to hear and to determine this particular issue. However, in the event that the tribunal finds that it has the jurisdiction to determine this particular issue, it is our submission that this matter is not admissible before this Honorable Tribunal.
Sorry, President, the time is over.
Right. Okay. I'll give. Yeah, just 1 minute. Let me just give a minute extension. Carry on, Clara.
Okay, I have a follow-up question here. If it is a case of admissibility, why first we discussed the jurisdiction and then the admissibility and not first if the case is admissible? I'm just asking.
Sorry, Clara, can you clarify that again? I didn't understand that
Yes,
too.
if the second issue is an admissibility issue, my question to the counsel is, if we have to discuss first the jurisdiction of the tribunal and then the admissibility of the case, or first we have to discuss if the case is admissible and then the jurisdiction of the tribunal.
You understand the question, counsel? Very simple. Which one? The horse or the cart?
Thank you very much, Honorable Arbitrator. And thank you for your question, Madam Arbitrator. We must first establish that this tribunal has jurisdiction to listen and to determine to this particular issue before determining its admissibility. Because admissibility is also an issue before this honorable court, and before this honorable tribunal. And if the tribunal does not have jurisdiction, then it cannot also assess the issue of admissibility. So first, we must establish jurisdiction. Then secondly, we can establish admissibility.
Okay.
To conclude on my point, honorable arbitrators,
Sorry,
Sorry,
I have a question. Regard to the monetary gold principle and the issue that you raised based on that the new government is a kind of third party in this hearing, I want to ask you about the page 88 of the case, paragraph 2. In this paragraph, it's mentioned that following the succession of Valderes, approximately 18% of the personnel of the PHO of Valderes, including most managerial staff, remained, and blah, blah, blah. The question is that the actually succession is not a real succession. Just the surface of the government change, but the core of the government and the actually managerial staff, the person who can actually decide about everything, is remained and actually are the person in the previous government. How can you actually justify that?
Thank you for your question, Madam Arbitrator. It leads me to my next point. Indeed, part of the staff in Valdres, the Republic of Valdres, after the secession, formed the Ministry of Health of the Republic of Valdres. That is not in contention. However, at the point of commission of this wrongful act, we must first establish the circumstances in that particular issue. Did the Republic of Valdres, through their provincial health officer, exercise autonomy in discharging their obligations? It is our submission that they did, in fact, have no autonomy over the decisions that they made. Allow me to point this honorable tribunal to.
Counsel, I'm very confused. Are you not submitting that, in fact, Arrakis should be a party and therefore this is not admissible? Or are you saying otherwise? You're for the respondent, you know?
Thank you very much, honorable tribunal. That is the submission of the respondents, that indeed the Republic of Arrakis should be part of this particular dispute, and as such, since they are not part at this particular moment, the case is not admissible before the tribunal.
Yeah, but your argument was otherwise. Okay, so does that conclude your argument now? Because you've taken far too long. Okay, thank you very much.
Thank you, honorable arbitrator.
Mr. President, her time is 23 minutes.
Yeah, but I think because of some questions, I will give some indulgence of the 1 or 2 minutes for the other side later. Okay, I believe now we should be listening, or rather listening to the counsel from the claimant side. Miss Kandi, is it? Oh, sorry, Miss Yvonne Kandi, Miss Kandi, yeah. Miss Kandi?
Honorable members of the
Honorable
members of the tribunal, my name is Fdim-Wa Yvonne Kendi, the first counsel for the claimant. This is Team 2 Chair. I appear alongside my co-counsel, Alex Kimani. I'll be delving into the issues of jurisdiction under Issue 1 and admissibility of the issues in light of the monetary gold principle objection, Issue 2, in 19 minutes, and I reserve 1 minute for rebuttals. My co-counsel, Alex Kimani, will be delving into the third and fourth issues in 19 minutes and reserve 1 minute for rebuttals. If there is no question from the tribunal in regards to the order of my procedure, I wish to proceed.
Please do.
Members of the tribunal, before the claimant can proceed to respond to the assertions of the respondent, we pause two questions before the Honorable Tribunal. First, what becomes of an investor's right when governments change and borders shift? Second, does investors' right vanish with political transitions? The claimant here invested in good faith through the undertakings provided under the BIT. Now, the trust has been shattered and the investment has been lost. The only hope for the claimant lies with this tribunal as the respondent continues to hide under technical objections such as the state succession and the monetary gold principle objection. The position that the claimants take in regards to the first issue is that this tribunal has the requisite jurisdiction to hear and determine the matter in light of the rules of state succession. Members of the tribunal, private rights acquired under existing law do not cease under the change of sovereignty, especially where explicit consent has been given. Now, if we may turn our attention to page 81, line 1810, we can see that none of the states to this dispute is a party to the 1978 Vienna Convention on State Succession. Therefore, since the respondent has not raised an issue in regards to the principle of automatic succession, we just wish to state it, that the principle of automatic succession does not form part of customary international law as it was established in the Ripaska versus the Republic of Montenegro under paragraph 286, the award on jurisdiction. However, there has been an explicit agreement to the BIT continuity. In advancing our argument, we will rely on three tenets. First, that there was an express agreement to the BIT continuity through the exchange of official notes. Second, that there was a tacit agreement to the BIT continuity marked by respondents' conduct post-independence. And third, that this tribunal has jurisdiction by virtue of the survival clause under the BIT. Members of the tribunal, if we may turn our attention to Claimant Exhibit 1 and 2 on page 13 and 14 respectively, these marks the official notes between Valdez and Zenera. In fact, simple exchange of diplomatic notes is one of the ways that treaties can be concluded in line with Article 11 as read together with 13 of the 1969 Vienna Convention and was reaffirmed in Uram versus Slovakia. The content of the note of Valdez to Zenera constitute a declaration of intent to be bound through its verbatim wordings, readiness to observe the treaties and agreements entered. While the note does not specifically identify the BIT or any other treaties in force with Zenera, the corresponding note of Zenera to Valdez clears the doubts that exist. The note starts by saying that the country will take into consideration and ends by reaffirming its position that the country is content to continue economic relations with the country, and in this regard, treaties that have economic character. The respondent council has asserted that the BIT is not one of economic character. However, by its nature, BITs reflect economic nature, and this therefore means that both Valdez and Zenera agree that at that point, to succeed to the BIT, Zenera Araki's BIT. If we can turn our attention, members of the tribunal, to the claimant's Exhibit 3, which provides the excerpt of the government website of Zenera, provides that Zenera at all material times believed the BIT was in force as it has published the BIT on its website. Now, by principle of estoppel, provided for under Mikara versus Romania, and later reaffirmed in Worldwide Minerals versus Kazakhstan, provides that the respondent is stopped from giving a contrary opinion. Having established that there was an express agreement to the BIT continuity, the claimant will now proceed to address the tribunal in regards to the tacit agreement to the BIT continuity marked by the respondent's conduct post-independence. Members of the tribunal, the respondent council has asserted that they sent a parliamentary resolution dated 15th of April 2023, which is marked as Respondent Exhibit 1 on page 49. Important to note, members of the tribunal, is that Parliament is not one of the bodies under international law that can bind a country internationally through its unilateral acts or declaration in line with Principle 4 of ILC Guiding Principle capable of creating legal obligations. Through its note, it also states that countries will not negate the treaty obligations unless they have agreed. This therefore means if the treaty was concluded as of 6th of February 2023, any negation, any termination of the treaty would be upon the agreement of the parties. As it was reaffirmed in Sanam versus Leos, unilateral internal acts cannot negate already established international obligation. This therefore means that a parliamentary resolution in this case is without merit. In addition to the parliamentary resolution, they have invoked the excerpt of its government website, which is marked as Respondent Exhibit 2 on page 50. This excerpt cannot be relied on.
Council, can you just stop? Can you repeat the particular exhibit?
The Respondent Exhibit 2 on page 50.
What page?
Page 50.
Okay, carry on.
It provides the excerpt of the government website of the respondent. If members of the tribunal, we can see here the Zenera Arakis BIT has not been listed. However, this does not mean rejection. If we can turn our attention to page 77, paragraph 44 and 45, we can see that several BITs have several treaties such as the Double Taxation Treaty, the bilateral trade agreement between Zenera and Arakis have been in continuous application but have not been listed. This therefore means that omission under the government website does not infer rejection. In addition to this, they sent us an official note dated 17th of August 2024, marked as Respondent Exhibit 3 on page 51. In this note, they clarify their position on the non-continuity of the BIT. Members of the tribunal, it is interesting enough how this official note comes 2 days after we have initiated this arbitration. In addition, their unilateral acts as per the agreement on the exchange of diplomatic notes cannot negate the already concluded treaty. While the respondent has not raised any regards in regards to the deletion of Article 8, it may be a concern before this tribunal and the claimant will now address it. On 15th of April 2023, there was the deletion of Article 8. Article 8 provides this tribunal with a jurisdiction when it comes to investor-state dispute settlement mechanism.
Okay, Clement, if I can stop you there. Thank you for raising this. I was going to come to that. You do look, okay, so the reason why you all are here before us is because of Article 8, right? Now, if you look at Article 8, I need to satisfy myself on this. Any dispute concerning an investment may arise, okay? Yes. It says, with respect to matters governed by the government shall be subject to negotiations between the parties to the dispute. If any dispute between an investor, one contracting party cannot be thus settled, the dispute may be submitted to international arbitration. To this end and in accordance to the terms, okay, all this it says blah, 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 okay. Then, of course, in advance and consent in submission of the dispute into arbitration. 2 quick questions. Did your clients take any steps to negotiate before filing the request for arbitration on 15 August? That's question number 1. So there'll be yes or no. If it's yes, I need to know now. If it's no, I need to know now too. Before I go to the second question.
Mr. Arbitrator, our client has not taken any steps regarding negotiation.
My apologies.
Our client, we have not taken any measures in regards to the negotiation procedure.
Okay, so you concede that. Okay, so bearing in mind you did not, okay, a simple question. Would you know why they did not? Are you in a position, do you have instructions to that effect?
Mr. Arbitrator, I understand your concern. However, the provision of Article 8 provides for investor-state dispute resolution mechanism at the same level as it provides for negotiation. Therefore, it means if a party does not wish to pursue negotiations at the very first stage, it can proceed as well to the investor state dispute settlement mechanism.
So you feel that the negotiation aspect is not like a condition that has to be satisfied. Is that your position, right? Is that?
Mr. Arbitrator, since the
Mm.
respondent has not raised it as an objection that the claimant should have.
I appreciate that, but leaving that aside, leaving the fact that they may not have raised, are you saying to this tribunal, I just want to hear yes or no, simple, that this is not no impediment to this tribunal to proceed to carry on hearing this?
It is
Is that the
imperative
client?
as it is imperative as provided under Article 8 that parties first assess or try negotiation first before it can invoke the jurisdiction of
Right.
this
So
tribunal.
since you agree with that, so what steps did your client take to
While
negotiate?
While our client has not taken any steps in regards to the negotiation, it still reaffirms its position that it has the right to invoke the jurisdiction of this tribunal.
Okay, fine. Thank you. Carry on.
Mr. Arbitrator, thank you for that question as it leads me to the last tenet on the issue of jurisdiction. That is the survival clause. By virtue of the survival clause provided for under Article 11.3.3 of the BIT, this tribunal has a jurisdiction. The respondent may aver that this was just an amendment, not a termination of the agreement. However, deletion of Article 8 is de facto termination of investor state dispute settlement mechanism, and this therefore means that the survival clause is with merit and suffices in this case. Having established that this tribunal has the jurisdiction, we will now move to the second issue on the monetary gold principle objection. Members of the tribunal, the respondent counsel has advanced an argument on the monetary gold principle objection. The respondent does not only challenge the existence but also the exercise of the jurisdiction of this tribunal. However, this principle has its exceptions. But first, before delving into the exceptions, it is important that we appreciate the establishment of the monetary gold principle objection. The monetary gold principle objection was established by the ICJ in 1954 in the monetary gold case and later reaffirmed in East Timor case. This principle essentially provides that where the legal interest of a third state form the very subject matter of a dispute, the matter will be declared inadmissible. The scope of application of the principle is not limited to courts as was established in Larsen versus Hawaiian Kingdom, paragraph 11.74, which provides that since tribunals operate under public international law, this principle is equally applicable before the tribunals. And as we can see later through the subsequent jurisdiction and before the tribunals, that tribunals have applied the monetary gold principle objection. The claimant will advance their argument on two grounds. That first, Iraqis is not an indispensable party in that their interests do not form the very subject matter of the dispute.
I'm so sorry. I'm going to stop here. If you are saying that Iraqis is not an indispensable party, first of all, I have to ask you, where was the data saved? In the servers of the PHO of Valdris or in another server?
Madam Arbitrator, totally understand your question and your concern. While the data was accessible and was put through the PHO of Valdris,
The data that was leaked,
yeah,
was saved in the servers of the PHO of Valdris or was saved in another server of the Ministry of Health of Iraqis?
the data was stored under the servers of FMH of Iraqis. In addition to that, it is important to note. In addition to that, it is sorry.
In Iraqis, not in the server of the PHO of Valdris. Why
Yes.
you are considering only to claim against Valdris when, if I am not wrong, there's no evidence or a formal evidence that it was a specific breach of the PHO of Valdris? Why you are considering that only it is available only Valdris and not to both countries?
Madam Arbitrator, I understand your concern in regards to the data being stored under the servers of FMH, and now we sue the respondents in regards to the FPS claim. While the data was,
yes, but you are suing only Valdris.
yes,
Why?
while the data was stored under the servers of FMH of Arrakis, it was accessible to the PHO of Valdris and the FMH of Arrakis. The claimant will demonstrate how Arrakis is not an indispensable party in the subsequent argument. Members of the tribunal, it is important to appreciate the definition of an indispensable party as was defined in Larsen versus Hawaiian Kingdom. An indispensable party is one which its absence means that the court cannot proceed to adjudicate on the merits of the case. This therefore means that the determination on the responsibility of the third state absent in the proceeding is a prerequisite before the court or a tribunal can decide on the responsibility of the original litigating parties. Members of the tribunal, inasmuch as the monetary gold principle objection suffices, it has its exception. One of its exceptions is that where facts of a third state are merely incidental, a court or a tribunal is not barred from exercising its jurisdiction. In this case, the claimant's position is that the facts of Arrakis are merely incidental and would just be used to build up a case for Valdris and would not mean that the legal interest of Arrakis form the raised subject matter. In this case, the claimant invoked the jurisdiction of the tribunal, asking it to rule on the responsibility of Valdris solely without touching on that of Arrakis. Members of the tribunal, we implore you to be persuaded by this narrow approach as it has been laid down in the recent case of Picharis Pildegovics versus the Kingdom of Norway in 2023, which has held that if the legal interest of a third state does not form the raised subject matter, then it means the tribunal or a court will proceed to adjudicate on the merits. In addition to this case, we rely on the case of Chevron and Texaco versus Ecuador in 2012 and Certain Phosphates case in 1992. Now, the claimant would like to establish to this court that in fact it can rule on the responsibility of Valdris without touching on that of Arrakis. Members of the tribunal, due to the separation agreement that existed between the parties established on the 20th of November 2022, Arrakis agreed explicitly that its obligations for the international wrongful act would be transferred to the predecessor state. They agreed to settle their predecessor dispute in light of the 2015 resolution of the Institute of International Law on State Succession in respect of state responsibility. The said resolution under Article 12.3 provides that where the unit of a predecessor state later become an organ of the successor state, it will bear the responsibility which it did when it was a unit of the predecessor state.
Again, I'm going, Counsel, sorry, but if you are going to quote the Article 12.3, I have to again ask how you can determine that there exists a breach of the PHO of Valdris in that moment when the data was saved in another server. How we
my
can
understanding
link
is that she's tried to answer.
The responsibility of the PHO of Valdris.
But hasn't she answered that question? I mean, I thought she has attempted to answer the question.
Yes, but I am not understanding why she is now bringing the Article 12.3.
Oh, I see. Okay.
Madam
Well, by the way, your time is up now.
Sorry,
just hold on.
It's finished. Yeah.
Hold on. The other counsel took another at least 3 minutes. I'm giving you 2 minutes to finish off your argument, including answering the question and then summarizing. Okay? Time runs from now.
Thank
the
you,
indulgence
Mr.
I'm giving you now. Actually, your time is just up now. Okay? Yeah. You answer the question first, and then subsequently you can summarize. Yes.
Thank you, members of the tribunal. Ms. Arbitrator, I understand your concern in regards to the data being stored, the servers being stored in the FMH of Arrakis, and later that we are suing just the respondent in this case. My co-counsel, Alex Kimani, will establish how the PHO of Valdris is the author of the alleged claim, therefore substantiating on why we are suing directly the respondent. In addition to this, we implore this tribunal to turn its attention to page 74, specifically paragraph 26, where it is provided that inasmuch as the information was stored, the servers are located in FMH of Arrakis, information regarding the technological know-how of the claimant was equally accessible by the PHO of Alriz.
Which
Members,
paragraph is that? Which paragraph is that?
paragraph 26 of page 74, statement of uncontested fact,
Right, okay.
the last line. It was accessible to both the PHO and the FMH of Alriz. Members of the tribunal, this shows that there was a direct connection between the respondent and the claimant in this case. And since the claimant has been investing in the province of Valdriz, it means that Valdriz will bear the responsibility of actions that it did even before it got the international capacity of a country as of 1st of January 2023. Members of the tribunal, seeing that my time is far much spent, I wish to conclude on all my issues. Now, this tribunal has the jurisdiction to hear and determine the matter. It also has it can also exercise its jurisdiction, and that the monetary gold principle objection cannot suffice. Members of the tribunal, we wish to remind you that the only hope for the claimant in our case lies with this tribunal, and we implore this tribunal to be persuaded by the provisions that we have provided and the jurisprudence produced. We thank you for the opportunity to be heard by you. Thank you.
Thank you, counsel. Thank you. Okay, before I move on to asking the counsel for the respondent to do the rebuttal, any questions from any members of my tribunal on these issues that's been
No,
raised so far? Okay, fine.
excellent. Thank
Okay,
you.
can we hear rebuttal short, please, 1 minute, yeah? Because you took a very long time in your arguments. Okay.
Thank you very
Carry on.
much,
Masaya,
Honorable
yeah.
Arbitrator. The claimants have averred that the unilateral declaration made by the Parliament in the Republic of Valdres are not binding. Allow me to refer this court to the case of New Zealand versus France, where the ICJ held in that particular matter that unilateral declarations could be binding if they were clear and unequivocal. In this particular instance, their declaration was clear and unequivocal, and as such, it could be binding between the two parties. Honorable Tribunal, the claimants have averred that Arrakis is not an indispensable party to this particular proceedings, and that any deep dive into the facts would only prove that they were incidental. It is a respondent submission that the facts relating to this particular issue, and particularly with the Republic of Arrakis, are not incidental in any manner. We will prove, Honorable Tribunal, that indeed the Republic of Arrakis exercise autonomy over the PHO's acts. Allow me to draw your attention to paragraph 19. Paragraph 19, page 73, as well as paragraph 26 on page 74. These two paragraphs show that indeed the FMH had direct supervision and approval of all the acts of the PHO. This therefore means that during the commission of these wrongful acts, Honorable Tribunal, it is the PHO in Valdres who was answerable to the Ministry of Health in the Republic of Arrakis, and as such, the Republic of Arrakis remains an indispensable party to these disputes. With that, I wish to cede the floor.
Right. Sir, rebuttal.
Members of the tribunal, the claimant in this case does not undermine the unilateral declarations or the role of a parliament, as indeed it reflects the will of the people of a country. However, when the treaty obligations or treaty continuity has been concluded, unilateral declarations cannot negate these, especially when they are unilateral internal acts or declarations. Members of the tribunal, this marks the ultimate end of the claimant's position in regards to the procedural issues.
Thank you. Okay. I think we are now moving on to the merits, right? And then I believe the claimant is going to be addressing us first. So, Mr. Joel, My apologies, Mr. Alex.
Post indented. Mr. President, honorable arbitrators, and esteemed opposing counsels, and everyone present on the platform today, receive cordial greetings from this side of the world. My name is Alex Kimani, and I will be taking you through the merits of the case, issue 3 on full protection and security, and issue 4 on the guarantee of free transfer. If there is no preliminary objection, I wish to proceed. Honorable
Proceed, please.
members, before I dive to the gist of our submission, I begin with this backdrop that we can all undoubtedly concur that all lies do corrupt and they are akin to wildfires because they destroy everything they touch. Submitting on our third issue that the respondent is responsible for the violation of its obligation to provide full protection and security to the claimant's investment under Article 3 of the BIT. Honorable arbitrators, Biompro made an honest investment in the Republic of Valdris with a legitimate expectation that its high-value data will receive full protection and security. However, that was not the case, as the respondent failed to take reasonable measures to prevent or respond to foreseeable harm. In the course of my 19 minutes, I will be establishing this in 3 main tenets as my roadmap. First, that full protection and security is not limited to physical protection of investments. Second, that the respondent failed to take reasonable measures to protect the claimant's investment. And third, that the respondent is the other of the alleged violation. Embarking on our first segment, where the claimants submit that full protection and security is not limited to physical protection of investments. Honorable arbitrators, this case involves a modern form of investment which is heavily based on intellectual property, specialized know-how, and contractual rights. Article 1 of the BIT broadly defines the term investment to include not just physical or financial assets, but also intellectual assets, specialized know-how, and contractual rights. We rely on the standard of interpretation laid under Article 31 of the Vienna Convention on the Law of Treaties, that treaties must be interpreted in good faith, based on their ordinary meaning and in light of the intended purpose. We implore the tribunal that under customary international law, it has embraced this broad interpretation of the obligation, and especially where the word full has been included without any limitation. As it was affirmed in the ICSID case of Biwater Limited versus Tanzania, and this specific case, members of the tribunal, it is analogous to our situation because it relates to intangible assets and particularly contractual rights, where the tribunal, under award paragraph 729, placed that the inclusion of the word full to the obligation elevates and extends it beyond physical protection. Honorable arbitrators, in conclusion to that limb, it is evident that from the inclusion of the word full and the broad interpretation of the term investment, that parties intended to extend obligation to cover this intangible asset.
Sorry, counsel, to interrupt you. I have a question. In my mind, in the rapidly evolving world, and in the age of technology, it's obvious that the intellectual property, including know-how and the trade secrets, is a kind of asset for the investors. My concern is not about the including IP under the full protection standard. My problem is that I think cyber attack it's a kind of force majeure in this case, because the host state actually couldn't foreseeable this attack, and it's not actually preventable and not foreseeable, because they do their best effort. They sign contract with the cybersecurity company to prevent this kind of attack. But although they signed this contract, they couldn't prevent and actually couldn't actually think that this kind of attack could be happen. So how can you justify that?
Most obliged, Madam Arbitrator. In answering your question, we will be in relation to our second tenant, which is that the respondent failed to take reasonable measures to protect the claimant's investment. Initially, we direct your attention to the case of Ampal America versus Egypt, where the ICSI tribunal found Egypt to be in violation of its obligation for failing to take preventive measure, and specifically under paragraph 285, where the tribunal made a remarkable note that they failed to take reasonable measures despite prior attacks which could have triggered preventive measures. In our case, Honorable
So sorry,
Arbitrators,
I'm going to interrupt you here because you're bringing this case. Your client is a company that it is not a new company, like it's a leading company in the industry. So, and you decided, like your client decided to invest in a least developing country, taking into account, and if you go to the email exchange before the signing of the contract, your client was concerned about the data protection. So, and also Iraqis was receiving, and all the region were receiving several cyber attacks and several attacks, not once, like they were receiving attacks from 2013. So that it was like 4 years before the signing of the contract. So how you can justify first that you have legitimate expectations that your investment should be protected in this regard, taking into account the condition of the country, taking into account the condition of the context of the attacks, taking into account that you are concerned, and secondly, how you can first, how you can determine that you have legitimate expectation, but plus how you can determine that the country did not make the efforts that they could to protect your investment. Of course, they are not, they don't have the best sources to do it. They are not United States, they are not Russia, they are not leading countries. So how you can determine that where the steps that the state took were unreasonable in this regard.
Honorable Arbitrator, I do concur with your position, and specifically on the fact that this country had limited resources. But on the same, we direct your attention to paragraph 3 and read together with paragraph 8 of the record on pages 70 and 71 of the problem, which when read together clearly show that this country has the resources, and this is because Arrakis has a wealth status of 150 billion, and putting to consideration under paragraph 8 that Valdris is the wealthiest province within this country. To the second question, as to what pertains to the due diligence which they owed to the claimant, we direct this tribunal to paragraph 29 and specifically on page 74, which, if we may move together, honorable arbitrators, where it clearly provides the reasonable grounds which were set by the GOD region, which were offered in order to safeguard sensitive information. These safeguards were offered in consideration of the economic status, and despite this, it is evident under paragraph 33, 32, and 34, and also in the FMH internal audit marked claimant exhibit 11 that they failed to take reasonable measures despite all of these recommendations and despite the resources they had.
Okay, so you are arriving to the point that I made to your co-counsel, and I want to hear about your opinion and your position regarding this. Like how you can prove that, okay, the PH of Aldris did not like follow the GOT recommendations, follow the Federal Ministry of Health recommendations, but like they comply like having another company that was cheaper, but the service that this company provided was less than the company that the Federal Ministry offered, etc., etc., etc. How you can prove that all the measures taken by the PHO of Valdres were a direct link with a cyber attack, and not the fact that the country were receiving cyber attacks, and maybe even in other provinces, like Valdres was not only the only province that was affected for this cyber attack. So I think there exists a fail in the system. So again, how you can prove that all this lack of due diligence that you are mentioning
Madam Arbitrator,
are
we do
and with the damage that you are claiming.
in showing the causal link between the breach and the due diligence part of the due diligence failure by the respondent, we do direct you to the FMH internal audit marked claimant exhibit C6, C11, which clearly shows with a high probability that this attack originated from the respondent. And this report, we want to note, honorable arbitrators, that it was made via collaboration by Arrakis FMH and the PHO. So this information is reliable to this tribunal. Progressing to our third facet.
Okay, I mean, okay, but respondent also presented an exhibit related to the internal audit made by the PHO of Valdres, where they have a contradiction with the Federal Ministry of Health audit. So what is your position related not to the exhibit that your client is presenting, to the exhibit that the respondent presented?
Honorable arbitrator, we do concur that they formed their own independent report, but it is our position that this report is biased and it is clearly limited under its scope because it only pertains to one system, while this one of the MFH is conducted through the collaboration of several agencies, so it has the probative value before this tribunal in comparison to the PHO internal audit. Progressing to the third facet, that the respondent is the other of the alleged violation of full protection and security. Honorable
sorry,
arbitrator.
I have a sorry. I'm really sorry, but I have a follow-up question. Okay, with your point, but it was not at the end, like the PHO of Valdres has some autonomy to decide, etc. But at the end was not the responsibility of the Federal Ministry of Health to control that all the PHO were implementing regulations.
Honorable arbitrator, to answer that question, it leads us to our third facet, where we will be connecting the author of the alleged breach to the respondent. And in answering your question, I direct your attention to page 57, where you will find the Constitution of Iraq is marked Respondent Exhibit 7, where under this exhibit, it clearly shows that healthcare coordination was a concurrent competence between the parties, and each party in this circumstance has to bear its own and has to stomach its own ramifications. And as was presented and as was articulated by my co-counsel, and this is by dint of Article 12.3 of the ILC guiding articles. Honorable arbitrators, proceeding to our third facet, which we have tackled while articulating most of the questions, we have only this persuasive case, which was based on the ICSID Convention, which articulated the real definition of an alleged breach. And this case was the case of Turkmenistan versus Mohammed versus Turkmenistan, sorry, and specifically under paragraph 681 of the award, where they said an international obligation or an internationally wrongful act occurs when two cumulative conditions are met. First, the act is attributed under international law, and second, the act must be attributed under the obligation of the country. And in this case, it is the claimant's position that both of these cumulative conditions.
Counsel, hold on. Counsel, we can't see you.
Pardon?
So we developed a technical.
We can't see you.
We developed a technical issue. Give us a minute.
Do you need some?
Okay.
I understand.
We've
Sure.
corrected.
Okay,
Can
okay,
you see
you're
us
on
now?
back. Okay, carry on.
So it provided under paragraph 981 that first an act must be attributed under international law before assessing whether it is deemed to be in breach of its international duty. And honorable arbitrators, we have established all of these two conditions conclusively. And it is our position based on the third issue that the respondent has violated its obligation to provide this full protection and security. Proceeding to our third issue, where it's the claimant's position that the respondent failed to guarantee free transfer of returns. Under this segment, we will be arguing under two main principal aspects. First, that there was unlawful obstruction and limitation of transfer requests. And second, there was discriminatory application of quota restrictions. And that is the order we will be taking to discuss the fourth issue. Pursuant to the first claim that there was unlawful postponement and obstruction of transfer requests, honorable arbitrators, we direct your attention to the case of Metaclad versus Mexico. And in this case, the tribunal addressed a dispute arising from ambiguity and unclear regulatory provisions. And specifically, they averred that unclear and ambiguous regulatory provisions require prompt rectification, failure to which amounts to a breach of international obligation. And in this case, the same has happened. If we may move together, honorable arbitrators, to page 79, and specifically paragraph 52, where it clearly shows, if we move together, honorable arbitrators, where it clearly shows that...
Counsel, you should give us time to look at the paragraph,
Okay.
please.
Page 79.
Don't worry, yeah, okay. And paragraph 52, right? You're talking about paragraph 52. Carry on.
Yeah. Under paragraph 52, honorable arbitrator.
Yeah.
Under paragraph 52, yes, it clearly shows that the respondent granted the central bank excessive authority and discretion, which enabled them to interfere with lawful repatriation of profits and further circumvent Article 4, as it is collaborated under paragraph 56 and 57. Honorable arbitrators, pursuant to that, under paragraph 55, it clearly shows that the respondent filed for 12 applications for the repatriation of 60 million USD. However, till date, the respondent has continued to stall, obstruct, and prevent the respondent from accessing these funds, which clearly amounts to a violation of their right. Honorable arbitrators, this consistent
Counsel, hold on.
creation...
Before you proceed further,
Yeah.
Your clients did receive certain amount of money, am I right? And what is the quantum?
That's under the same paragraph 52. It was 20 million USD.
Okay, and from what I can see, there were requests that were made by the respondent, questions raised, guide and timelines given, but your clients delayed each time in giving the answers. And there was one last request that was put forward, or other questions put forward, which your clients never bothered to even answer as it stands. So to what extent should we actually accept your contention totally? I mean, I can understand there were some issues here, okay? But I mean, I'm just trying to balance the facts. One, delays on your client's part in answering questions where you got the money. And there was, with the last part, it seems there was no answer given at all. Would you know why?
Pertaining to that question, I have no instruction from our clients.
Right.
But pertaining to the first question, as to whether our failures should be taken into consideration, we urge this tribunal...
I won't say failures, but delays, okay?
Okay, rather delays. Honorable arbitrator, we do note that we made several requests for information, but they clearly disregarded our request, and this clearly relates to the ambiguity and passive administrativeness, which was alluded for by in the case of Metaclad versus Mexico, and that clearly... okay.
Okay, you may want to move on quickly because I don't think you have much time now.
I request 2 minutes on my last limb.
No, you actually have you have 2 minutes of your own time. So carry on, don't worry.
Progressing to discuss
Proceed,
our
please.
final segment, where it's our stance that the respondents are discriminatory applied quota restrictions. Honorable arbitrators, Article 5 of the BIT.
Sorry, counsel, to interrupt you. I have some question. You can write down, and after that, you answer respectively. The first question is that
How many, wait, how many questions do you have? I hope,
two
keep
or
it
two
short, please.
two or three. It depends on the answer that actually the council give me. And the first question is that do you believe that the act of the respondent is a kind of creeping expropriation or the breach of full protection standard?
In answering your question, it is our assertion that it's a violation of their obligation under the treaty, but not it does not necessarily amount to an expropriation of the investment.
Mhm. I believe that it's a kind of creeping expropriation because they provide you full protection. But the other question is that actually, I believe that the respondent used the police power doctrine for their action because they do this action based actually for their country's benefit, for the nation's benefit. And how can you justify the use of police power doctrine by the respondent? And the other question is that you mentioned that their act is actually discriminatory action, but the other company that actually led them to transfer their funds, their budget, was in the field of, I think, if I'm not wrong, medical sphere, not pharmaceutical sphere. And I think these are very different to each other based on the Cambridge definition of these two words and based on the healthcare industry actually customary. These two fields is really separate each other. So I believe that it's not a discriminatory action. How can you justify these 2 points? The first, the police power doctrine, and the second, the difference between two sphere of the to the industry. Thank you.
Most indented.
Sorry, can I just interrupt? I think what you can do in answering the question, just put forward your arguments, and indirectly that's going to be answering, because otherwise, okay? Because I think you were going to develop that point before that my fellow arbitrator raised that. I think you have not raised that yet. So just develop your arguments, and I think they'll be answering the question.
In developing my arguments, honorable arbitrators,
Quickly,
it
you have
was
about 2 minutes.
okay. It is our position that there was discriminatory application of these transfer restrictions, and this is by dint of a decree number, the national law number 48, which clearly bases this monetary cap on the certain fields, and this is specifically mining and pharmaceutical, and the other one consecutive. And this clearly shows that all fields that fall under the pharmaceutical ambit are clearly within this statutory limit. As we can move to paragraph page 39, where it clearly shows that these companies deal with pharmaceutical products, despite the assertion that they are not the same commodity, that they're not the same products, but they fall under the same field of pharmaceutical and are further guided and under the same legal measures as the claimant. So this clearly shows that they are in line. And we direct the tribunal's attention to the case of Fdim-Wa versus Canada. This particular case dealt with the same facts, and it concluded that it leads operators operating in like circumstances. And this phrase, like circumstances, was further elaborated in the case of Saluka Investment versus versus Argentina, where they averred, sorry, honorable arbitrators, in the case of Saluka Investment against the Czech Republic, where they made a notable observation that it needs to be understood and all the companies falling within the same practices and nationality not being the discrepancy. In light of the foregoing, honorable arbitrators, it is the claimant's request that this tribunal declare that it has jurisdiction to hear and determine the present dispute and subsequently order and declare that the respondent has violated Article 3, 4, and 5 of the BIT.
Thank you,
Perceiving
Counsel.
that my time is utilized, I yield the floor back to the bench.
Thank you. Okay, we will now move on to Mr. Joel to respond.
Very much
Can I,
obliged,
before
Mr.
you start,
Presiding
Mr.
Magistrate.
Joel, before you start, can I
Yes.
request my co-arbitrators to try to ask the questions in a succinct manner, rather than, because time is really running too. I mean, to be fair, right? Okay.
For sure, Mr.
Yeah,
Arbitrator, for sure.
yeah,
Thank
thank
you.
you. Okay, carry on, Mr. Joel. The 19 minutes starts
Very
now.
much obliged.
Yeah.
In my 19 minutes, Mr. Arbitrator, I will seek to submit on the respondent's case with regards to the alleged breaches of Article 3 on the full protection and security and Article 4 on transfers. Before I do make my submissions, I would like to ask that the tribunal considers this particular question because it's very key in my submissions. Where did the alleged breach take place? With that, with regards to the alleged breach of Article 3 that has been made by counsel for the claimant, we will be making two submissions. The very first one is that there is no territorial or factual nexus to attribute liability to the respondent state. And secondly, that if at all the FPS standard is to be applied in this particular case, therefore, we submit that the obligation of due diligence was duly discharged by the respondent state. Members of the tribunal, if you will indulge me, I'd like to take us to a clear reading of Article 3 of the Bilateral Investment Treaty, which is to be found in page 83. And this particular article will be the one that guides us on how to attribute liability and what kind of actions that are actually prohibited in this particular case. If I may read verbatim, and if the tribunal is with me. Investments and returns of investors of each contracting party shall at all times enjoy full protection and security in the territory of the other contracting party. Now, more importantly, neither contracting party shall in any way impair by unreasonable or discriminatory measures the management, maintenance, use, enjoyment, extension, or disposal of investments in its territory of investor of the other contracting party. Members of the tribunal, the actions that will violate the FPS standard under Article 3 are 1, either unreasonable or discriminatory with regards to the use, management, maintenance, or enjoyment or extension or disposal of the investment. Members of the tribunal, it has been submitted that indeed the respondent failed to accord the claimant's investment due security because allegedly due diligence was not conducted. We will submit that the standard of due diligence is not one of strict liability, but one that is supposed to be shown through reasonable efforts.
But let
Members
me
of the
stop you
tribunal.
there. I don't think, if I may just stop you there. I do not remember the claimant saying that it's strict liability. They did emphasize is basically that due diligence was not exercised. Correct me if I'm wrong,
Definitely.
but I think I do not remember hearing the fact that they're alleging that your clients should have, that there should be strict liability,
Members of the tribunal
Yeah.
are much obliged for that correction. However, while that was not what they mentioned, their submissions were to lead to that conclusion. And we will demonstrate that as established in AMT versus Zaire, it's not a strict liability obligation, but one of due diligence. And as reiterated in Orazul versus Argentina, that a country, therefore, faced with an obligation to provide full security and protection, ought to do so with reasonable efforts. These reasonable efforts were held in Tekfen versus Libya to be the ones that are supposed to be exercised by a country in like circumstances. We will demonstrate, members of the tribunal, that the Republic of Valdris, as a province of Arrakis, did exercise due diligence that is commensurate with its standards as at that time. Members of the tribunal, if I may guide the tribunal to Cybersecurity Circular number 12 of 2023 that was put in place by the government of Arrakis, that was consequently implemented by the PHO of Valdris. It has been argued that the claimant exhibit number 11 provides and indeed attributes liability to the respondent state in what the claimant called a high probability or a high degree of accuracy. Members of the tribunal, that particular report, by the report of 12th February 2022, the respondent state did indeed audit its own systems and provided another report that demonstrates clearly that there is no way of determining where these failures actually occurred. It was therefore not conclusive on who is to be blamed. The claimant relies on the report by the FMH that demonstrates that there was unclear or rather inadequate training on the part of the respondent with regards to their officials as at that time. Members of the tribunal, if I may guide you to the statement of uncontested facts, paragraph 34, which particularly details also the request or rather the issues that were mentioned with particular exhibit C11. That is paragraph 34. After the cyber attack, the Federal Ministry of Technology, working together with Valdris PHO, conducted an extensive internal audit to assess the extent of breach and shared it with the ministry and the PHO. Now, if we may skip that to paragraph 34, or rather to the last line, that is 1655. However, due to lack of certainty, or rather absolute certainty as to the scope of the leak, neither the FMH nor the PHO of Valdris from BioNPro informed BioNPro about the potential theft of their technology. Members of the tribunal, both parties, as at that time, could not ascertain the extent of breach and whether this alleged breach actually occurred as at that time.
Okay, Counsel, since you brought this to our attention, I mean, this didn't cross my mind, but since you brought this to our attention, what was stopping your clients from just informing, hey, there has been a cyber attack. We're not sure whether there's been any breach in relation or whether there's any leak of any data kind of thing that you provided to us. What was stopping your clients from informing the claimants or
Very much,
BioNPro? At that time, they were
very
not the
much,
claimant yet. There was no,
definitely.
yeah.
Very much obliged, Mr. Presiding Arbitrator, for your question, which actually now leads me to our final limb of argument on this issue, that there is no territorial or factual nexus for liability, and in any event, the Republic of Arrakis is the one that bore responsibility for any violation that has been alleged for Article 3. Members
So
of the tribunal?
you're going back to what your previous counsel was arguing about.
Definitely.
Okay, but I think okay, but I rather that you focus on the issue in relation to Article 3, whether there's a breach and what would be the defense, if any, on your client's part.
Members of the tribunal, the defense on the part of the respondent is it's not in violation, and if there is any violation, it's attributable to a different party. And as at that time, that party actually is the one that had control over the PHO of Valdris, as I asked the question that I began with. Where did the breach occur? Members of the tribunal, if you go with me at paragraph 16 of the Statement of Uncontested Facts, page 72.
No, but
The
are you
tribunal,
saying that the breach, did not occur in Valdris? Because Valdris was part of the
yes,
provinces. Where is that fact or a fact?
thank you, Mr. Arbitrator.
Can you bring it to our attention?
Please accompany me to paragraph 16 at page 72 of the Uncontested Facts.
Okay, because I think there's also another para which says otherwise. Okay, carry on. Because of the Constitution, healthcare falls, blah, 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 blah.
Yes, at paragraph 16,
I'm
let me just
reading out
summarize.
quickly. Yeah.
Oh,
No,
I'm so sorry.
let us read it, okay?
Okay.
Okay, this is about talking about foreign investors and all that, okay? About the problems. We are not talking about the breach.
Members,
We're not talking about the
allow me.
cyber attack. Yeah,
Allow me.
yeah. Carry on.
The second last line in that particular paragraph, the technology of medicine production, however, will be transferred to Iraqis on a federal level to enable its spread across all provinces. That was prior to the agreement with the claimant. Now, if you will go together with me to page 74, paragraph 26.
Yeah.
Counsel, sorry, but I have to stop here. What the contract of the technology of transfer? Who were the parties of this contract?
It was the claimant, the FMH, and the PHO of Valdris.
Okay,
In fact, Miss Clara, paragraph 26 is the answer to your question indirectly.
No. I know.
Yeah.
I wanted to hear from him.
Okay.
Okay, so if it was only one of all PHOs that there exist on Iraqis, why you are quoting this statement? Because it is clear that at least the contract of your client was with the PHO of Valdris and the Federal Ministry of Health. That's it.
Members of the tribunal, very much obliged for the question. As the earlier question indicated with regards to the constitution of Iraqis and the shared competencies between the Republic of Valdris, or rather between the PHO of Valdris and the FMH of Iraqis, you will note that this was indeed not exclusive. It was not an exclusive duty, and therefore it had to be shared. And at that time,
what about the Article 12.3 of the state of succession of responsibilities that the claimant brings on the table? What is your opinion regarding, what is your position regarding this article?
Ms. Clara, can you tell me the page of that one? Just for my own record.
No.
I think that's, no, you are bringing the document to our attention. Which page is that? You were referring to something, right, Ms. Clara, earlier?
It is not a document, it's an article that brings, I'm bringing you.
Oh, I see, okay.
Here is the link. But this is something that the claimant brings on the table on the discussion.
Sorry, okay.
So, particularly Article 12.3 that says that in particular circumstances, the obligations arising from the commission of an internationally wrongful act by the predecessor states pass to the successor states when the author of that act was an organ of the predecessor state that has later become an organ of the successor state.
If I may answer.
So I want to know your position about the application of this article.
Thank you very much, Madam Arbitrator, for your question. Now, in answering that question, the position of the Republic of Valdris is that the PHO of Valdris was not the author. And I was trying to demonstrate to you that the offense did not occur within the jurisdiction of the PHO of Valdris, and therefore Article 12.3 will be inapplicable in this particular case. If Madam Arbitrator is satisfied with my answer, I may wish to conclude my argument. Very much obliged. Members of the tribunal, the respondent in this particular case has demonstrated that there was indeed due diligence that was conducted and that it was commensurate with the standards of the claim, or rather the respondent, as at the time of the occurrence of this particular alleged breach. We have also demonstrated that the PHO of Valdris was not the author, and therefore no responsibility should pass, and if any, the claimant should go and sue the Republic of Valdris, or rather of Arrakis. Members of the tribunal, seeing that my time is far much spent, I'll wish to move to the alleged breaches of Article 4. In this particular case, we will submit...
Before that, counsel, before that, can I just ask my co-arbitrators, let me know how many more minutes are there? She's keeping time, because I lost track.
Yes.
I believe he only has about three
minutes? 14 and a half minutes.
Taken up already. So it's about 5. Okay, about 5 minutes. Okay, carry on, counsel.
Very much obliged. With particular issue with regards to the issue on alleged breaches of Article 4, we will submit in 3 limbs. First, that the claimant is the author of its own misfortunes. And secondly, that if at all there was a breach of Article 4, if any, there is a qualifier, or rather there is a defense for the respondent in Article 7(1)(b) of the Bilateral Investment Treaty, as the measures that were taken were prudential in nature. And finally, we will qualify this defense by making the submission that the measures that were taken were not discriminatory, as Ecovista, Killis Incorporated, and the claimant are not in like circumstances. Now, if the tribunal is satisfied with the order of my presentation, I will go to my first limb. Members of the tribunal, it has been held in Carlotti Metals versus Peru that compliance with the domestic laws is a prerequisite to protection. This position was also reiterated in Kotek Mining versus Kenya, in which the tribunal held that the withdrawal of a license that was improperly obtained was actually proper, and therefore the claimant did not have a protected investment. Members of the tribunal, the claimant was seriously and frequently requested to provide various information, which it failed to provide for a period of almost 3 months. In any event, the claimant was aware that the respondent was actually had, there was currency, or rather, it did not have enough currencies to enable it process the amount of requests that were being made. The claimant claims that they made 12 requests between May and December 2023, amounting to over 60 million US dollars. Members of the tribunal, we will submit in our next limb that these particular circumstances could not allow the respondent to allow such repatriation of profits, given the circumstances within which a new republic that it introduced a new currency was operating in.
Okay, so counsel, if that is a position that your client is taking, why then did they allow? Okay, forget about whether the other 2 companies are pharmaceutical companies or whatever. If there was a problem with cash flow, why then even the amounts which were given to the other 2 companies? Like I said, I'm not going into this argument about whether it's discriminatory as such, and whether they're can be considered as pharmaceutical companies. Leave that aside at the moment. The fact that if your point here, this is your point, that you guys had a currency problem, your clients, why then give out money to the other 2 people, to the other 2 companies?
Members of the tribunal,
it doesn't make sense, does it?
It does. It was not a blanket cover denial of currency. There were procedures to be followed, and our submission is that the claimant failed to follow these procedures and failed to provide the requisite information in order to process those payments. The claimant has not shown.
This is what I'm hearing.
The other companies.
This is what I'm hearing. Counsel, this is what I'm hearing from you now. I thought the earlier argument was there were some financial constraints. Didn't you say that?
Indeed.
Right. So, okay.
As I said, the financial constraints were not blanket. There was a due process that was supposed to be followed, and the claimant failed to follow that process. The claimant claims that it was in like circumstances with the ones that were allowed that Mr. Presiding Arbitrator has mentioned. Indeed, they were allowed. The claimant has not shown that these other companies failed to provide the same information they were requested. It has not demonstrated that they were in the same circumstances, that they disobeyed the the Central Bank of Valdris in providing the requisite information, and therefore they were not, allowed to repatriate profits. We therefore submit to that extent the measures that were taken were proportionate. Members of the tribunal, I see my time is far much spent. If I may request 2 minutes to make my arguments on the defense in Article 7.
Sorry, Counsel, to interrupt you. I have a
Yes.
question. As you know, the gradual removal of property rights from foreign investors through a series of government initiatives, like actually new legislation, like something that your government do, is a kind of creeping expropriation. And after happening this kind of acts, you have to do a full reparation for the investor. How can you defend your clients in this position?
Very much obliged for your question. In order for me to answer the question, seeing that my time is far much spent, may I request 2 minutes?
Yeah, you have asked for 2 minutes. Yes, quickly. Take the 2 minutes.
Very much obliged. Thank you very much for your question. It actually leads me to the submission that we need to make under Article 7(1)(b). However, to quickly answer your question, currently before the tribunal, the claimant has not put a claim for expropriation, and therefore we do not have requisite instructions to respond to the same. But to demonstrate that the measures that were taken are actually in accordance with the law, we rely on the case of Air Canada versus Venezuela, in which the tribunal held that a state has regulatory space to adopt capital controls when it is faced with balance of payments. In this particular case, the respondent state was actually faced with a similar situation, and therefore it did so in good faith. In fact, you will note that before the crisis got severe, the claimant was able to repatriate $20 million US. And when it did, it actually imposed stricter measures requiring them to provide certain documents to enable it stabilize its currency. We submit that this defense, as qualified under Article 7(1)(b) in the Bilateral Investment Treaty, as agreed between the parties, is applicable and serves the purpose it was meant to do, to allow the respondent state operate fully. To that end, it is our submission that there is indeed, if at all there was a breach of Article 4, there was justifiable reasons under Article 7(1)(b) of the Bilateral Investment Treaty. To that end,
Counsel, your
I
time
will
is
wish,
up, yeah.
yes, I want to
Yeah.
conclude if there are no further questions.
Thank you.
Very
Let
much
me just
obliged.
Thank you. Let me just ask my co-arbitrators, any questions?
No, thank you.
Okay, thank you. Okay, can we have the rebuttal then from Mr. Alex?
Honorable arbitrators, we do have 2 points of contention to address in our rebuttals. The first is the assertions made by our opposing counsel that this liability, and we do concur with them to the extent that this liability is not absolute and does not entail strict liability, but as it was held in the case of AAPL versus Sri Lanka, that this liability requires the host state to take reasonable measures to protect the claimant's investment, nothing else rather than reasonable. To the second ground of rebuttal, we aver that the PHO internal assessment marked Respondent Exhibit 7 is clearly biased by the dint that it was conducted by their own selves, which serves and they serve as their own judge, jury, and executioner in this case. So it lacks that probative value required. Honorable arbitrators, seeing that my time is well utilized, and before ceding the floor back to the bench, I thank you for your time and your kind attention. I cede the floor back to the bench.
Thank you.
Thank you.
Thank you. Okay, Mr. Joel.
Thank you very much, Mr. Arbitrator. In a quick rejoinder, I will begin with the last point that indeed they have asserted that the report by the respondent is biased. I wonder how then you will treat the FMH report that was done by the respondent, by the state of Arrakis that is not available here, that fully blames the respondent state for those actions. Indeed, bias is all over. And therefore, those two reports, actually, as reported in procedural order number 1, were held to be inconclusive, and parties agreed to that end. On the issue that was raised on reasonable measures, members of the tribunal, I did submit on the strength of Fdim versus Libya. The measures that were taken by the respondent were commensurate with its economic status as at the time, and therefore, that ought to qualify as enough due diligence for the reasonable efforts, as I cited the case of Orazul versus Argentina. Very much obliged. If there are no
Thank you.
questions, I will seek to rest the defense.
Thank you.
Yeah, okay. Before I bring this hearing to a conclusion, I think it is just right that I should ask my co-arbitrators as to whether they have any questions or clarifications on any issues from any of the councils here.
No, I don't have. Thank you.
Okay, Clara, nothing? Thank you very much. Okay. All right, so that would mean that I think we can safely say that we have come to the conclusion of this hearing. And I think at this juncture, what is needed is that we'll have to ask the secretary to sort of move you all out and then subsequently to move you all back, because we don't have to give any feedback, but what we have to do is confer amongst ourselves as to who we feel sort of has the edge in this, as far as which team sort of has the edge over the other. And then we will make known the result to the secretary concerned. And then, of course, when you all come back, we have to announce it to you all. All right. So I've invited the host now. So I think they'll be doing the needful of taking you all off, or rather moving us out, so that we can confirm that we come back. But make sure that none of the teams should actually leave. Okay, because there was a previous one I had where one of the team left. So you all should stay back and not completely leave, because you'll be asked to come back in about 5 or 10 minutes. Give us just a couple of minutes for us to confirm ourselves. Okay, is the secretary here? Oh, I don't see her yet.
No, for now, no.
Yeah, she's not here yet. Hello, Miss Chaudhry. They also very. I keep on inviting the host. Oh, I see. The host has been. Okay. They probably got upset with me clicking so many times. What was it you were sharing, Clara?
Sorry?
You were sharing something just now in the chat. I just saw that. No, the Microsoft Word, what? Final text. Oh, the correct, the document. Okay, right.
It is the
Miss Chaudhry, what are you going to do now? You can move. Are you moving us out, or are you moving? You're
I
muted.
think because Madam Arbitrator could not unmute herself in the other room, I will try to move the participants there, and then once the decision is made, I can move them back into this chamber.
So we stay here, right? Yeah, we
Right.
better stay here, otherwise we will lose
Right.
Miss Rane.
So I'll just move the participants to the hearing.
Thank you.
disclaimers or otherwise, we just have to mention whatever the decision was. Or they can hear us anyway. Okay. Okay, can you all please have your videos on? I just want to make one short announcement before I ask my co-arbitrator to announce the result. We had a long deliberation, well, not that long, but long enough. And we, of course, we are not here to give you any feedback, but we just want to say that I think basically the position that was held by all of us here is that arguments are all very cogent. You all were good in that sense. You all exuded confidence, okay? And the points were covered generally. And I know some of us were asking some tough questions. Some because we were making comments and the question that came about. Whatever it is, a decision has been reached. And I'll be asking my co-arbitrator, Ms. Clara, who's in fact one of the authors, by the way, of this problem. So you all should be honored to the fact that she was one of us in this tribunal. That I'm also honored to, but actually that's why, and that I had, but by the way, just to let you know, this particular issue about whether that one happens to be like a condition in relation to the negotiations, it's something which I had brought up when we had our own powwow arbitrators with the authors of the problem. Okay, and I never got a satisfactory answer. So okay, all right, okay, now Clara, all yours.
Okay, so I have the confirmation that both teams are traveling to Boston, so we are not. Like, it is just hearing one win, one lose, but because these are the rules. So the team that won this hearing is the team of the claimant. So congratulations.
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 But congratulations to both teams. You did an amazing job. I hope to see you in Boston in October and November. Okay, so good luck.
Yeah.
If you need
I may see you all online, of course.
Yes, of course. We are going to miss you, Aziz. So
no, I mean I can't come, but I'll definitely be online if Mr. What's his name? What's my Greek friend?
Dimitrios.
Yes, of course. Yes. I would have loved to be there with him to have some, shots of vodka and all that. Or rather,
I know that
whatever.
you could come, but I understand your protest.
I can't.
I understand
your
protest.
Correct. And not only that, I'm traveling. Like this month of August alone, I'll be in Thailand, I'll be in China, and I'll be in Korea. And 2 places is training. One statutory thing, one KCAB thing. So, and then September again in Kota Kinabalu. October again probably in Seoul for the Korean week, arbitration week. So, too much of, I can't afford it, put it this way. My Amex bill is rising, hitting the roof.
So,
okay.
I think we can let the teams go now.
Anyway, good day,
to
guys.
Celebrate
Thank
one
you
way
very
or another
much.
Because they're both qualified for the globals.
All right. Okay, I'm gonna
and start preparing for their travel.
Right. Yes. Okay. Thank you, Miss Rihanna.
Thank you.
Rehane. Are you on LinkedIn? Are you on LinkedIn?
Yeah. I actually sent a request
By
to you and for